Welcome back to another episode of Like That Law. I'm your host Benjamin Ho, and today here with us is Miss Deeba Manain, who is my lecturer here at the University of Reading Malaysia. She's a wonderful lecturer of multiple modules, but most pertinent to today would be the family law module. Before we start, would you like to give us an introduction?
Hello, everyone. Thank you for inviting me here, Benjamin. Well, I'm Miss Deeba. I teach at the University of Reading Malaysia, and family law is my favorite and my passion, I must say. Yeah,
that's great. I think family law is definitely one of the more enjoyable modules too. I think with all the drama and the intersection of the law, sometimes the law can be hard and dry. I think with contract law, that was one of it. But you did manage to make it quite lively, I would say. So
I'm glad you enjoyed it.
Yes, I did really much enjoyed it. I think we can dive into today's topic at hand, which is divorce here in Malaysia, mostly relating to Section 51 and the cases that have come out from it before. Would you like to go through an introduction to a pre-amendment LRA? What's the issue with Section 51 and what happened afterwards?
Okay. In terms of divorce law, right, there have been considerable changes, especially with the grounds of divorce. If you look at Section 51, right, which was considerably amended in 2017, okay, the pre-amendment, right, it posed a lot of challenges, especially relating to the jurisdiction issues between civil courts and the Sharia courts. Yeah, Section 51 typically allows for a ground where if one of the spouses has converted to Islam, that can be a ground for divorce, right? Prior to the amendment, okay, and only the non-converting spouse was entitled to apply for a divorce and ancillary relief under the LRA. Okay, which means that the converting spouse could not apply for a divorce under LRA because he or she is a Muslim now. All right. There was also another challenge whereby there was a 3 months waiting period. Okay, so once one of the parties converts to Islam, the non-converting party has to wait for 3 months before filing for a divorce. Okay, this is in line with the iddah period, okay, whereby the non-converting spouse is given an opportunity to think about conversion, okay, together with the converting spouse, right? So during this period of time, so many things can happen, right? And given the fact that the converting spouse cannot apply for a divorce under LRA, if they go to the Sharia court wanting to dissolve the civil marriage, it becomes a jurisdictional issue.
So this jurisdictional issue that we speak of, does the law treat the ground of divorce, especially in Section 51, this ground of divorce as a fault on the Muslim party, and so does not allow that party to initiate the divorce, or is that a subject area that is missing from the drafting of the legislation thereof?
Interesting question. It is not fault-based, but rather conversion to Islam is a fact. Right? So it's a fact, right? Conversion has happened. Therefore, based on that ground, I would like to divorce. But it was interesting why the party who has converted was not allowed. It could be because where the wordings of the statute said the statute applies to non-Muslims. That could be the reason why. Yeah. So
when we talk about this issue, now that we have moved past from the pre-amendment Section 51 now to a post-2017 amendment, which included quite a number of changes, but I think this is one of the most important ones at hand. Does this now affirm previous case law? Does it change the case law in any direction that we can think of?
Yes, this is very much in line with landmark cases like Viran and also Indira Gandhi, where it has been established very clearly that Sharia courts will not have jurisdiction to dissolve civil marriages and matters relating to that. Right? With the amendments that has occurred now, the converting party, the Muslim person now, is entitled to apply for a divorce under Section 51. So either party can make an application under the Section 51 ground, and they can also go under Section 52, mutual consent, okay, divorce by mutual consent, which is a very amicable solution. And they do not have to prove that the marriage has irretrievably broken down due to this fact. Right? So it's a very mature and amicable way, really, to file for a divorce. At the same time, the non-converting spouse can still go under Section 53 to prove that there is an irretrievable breakdown of marriage. So it has diversified this. And they have also abolished the requirement for 3 months of waiting period, which was required under Section 51. Yeah.
So this now puts then the Muslim and the non-Muslim on equal ground in terms of the LRA, which applies to all civil marriages. Does the jurisdictional issue now pose a question that there's similarly posed in Indira Gandhi? Because I think in Indira Gandhi, it was said that, so for example, Section 1211A, which is the ground which oust the civil court's jurisdiction on matters relating to Sharia, does that now, do you see any foreseeable challenges with the 51 drafting, or do you think that's very much complete?
In my opinion, it is complete. All right, it's complete. Indira Gandhi has got multifold of issues, right? Starting from the divorce to unilateral conversion of children and to custody matters. All right. So all this, if you ask me, boils down to the issue of jurisdiction of court, which is settled at the moment. Right?
Yeah. Which is settled at the moment. When you said that it's settled at the moment, I wanted to ask you, do you think any sort of other issues could arise? Because, as we know, Malaysia currently is at a very turbulent time in terms of the judiciary, which is currently seeing a panel retiring from the bench without any sort of immediate replacement. The law at the moment is not moving in any sort of reform direction that we would like to see it. Do you think there could be a regression, or do you think that this law is really that robust that we can see not really a lot of things that can come along the way that could break the current status quo?
It took such a long time for the amendments to come in. It took landmark cases after cases, right, to arrive where we are now, all right, where there could be challenges, okay, but I think family law is an area where it changes constantly because it's very much driven by societal changes. I always emphasize this in class, yes, right? So the policy making and how changes happen, right, to law, very much correlated to the societal changes. Sorry about that. Now, if you look at how things work in England, all right, we would think that, well, even in the LRA, the Malaysian statute, we say that if there's any ambiguity, we can refer to English law, right? The English law itself, it took so many years for them to arrive to a point where they move away from fault-based grounds or fault-based facts, right, to reach to non-fault-based divorce law. And only very recently, they have come up with mutual divorce. See? So, it takes a long process, I must say. Yeah. Changes are inevitable because society is changing. Yeah.
When you say society is changing, do you think in Malaysia, for example, I think where we do see a multiracial composition of our people that involve multiple races, and especially in this case, the interfaith marriage that is of note here. Do you think that the current setup of Section 51 and the division between the civil court's jurisdiction and the Sharia court's jurisdiction, do you think that we are moving towards a more conservative pace now, or do you think we're moving more towards a secular pacing with regards to the reform direction? Because I think there are a lot of voices around this sort of issue, and it can get really contentious, as we have seen from Indira Gandhi and the media coverage of it. People who have started to voice out about certain concerns about the degradation of the Sharia court's jurisdiction and applicability in their faith. Do you think this is something that Malaysia is equipped to handle, or do you think the law as it is currently is as best as we can get?
I would say that we are moving towards clarity.
Okay.
That is, I think, the right way to put it, right? Challenges are unavoidable, right, in a multiracial setting, but certainty and clarity is essential in law, because we are dealing with people's lives and livelihoods. So it's so important. At the moment, like I said, it is rather settled. Okay? There is clarity. If we are looking at Section 51 as the ground itself and how divorce is managed, that is settled. And the jurisdiction of courts in this area has been settled as well.
I think what strikes me with your tone is that you have this cautious optimism of how Malaysian family law is at, that you're not willing to go so far as to say that it is that well settled, but it is rather settled.
Smart.
But I think it is very...
But I do believe that it is settled, I must say.
Yeah, I think...
Yeah. And in fact, this is very unique to us, how we have this dual system, right? Of course, it is part of a single Malaysian legal system, but we have got two different courts here, right, with their own jurisdictions. We don't have this issue in England, for example, all right? So it's very unique to us, and I think we have come a long, long way. Yes.
I think that's great. Moving on to it, I think Section 52, 53, and other ancillary matters. Do you want to highlight anything of particular note here, such as, as you have mentioned before, in England now they have moved away from fault-based breakdown of marriage as a ground for dissolution to now declaring that there's only one ground, which is irretrievable breakdown of marriage as a ground of divorce. Do you think that Malaysian law should change in keeping with the reform in England, or do you think that this fault-based marriage thing still has its function here in Malaysia?
Right. Well, it has always been a sole ground. Irretrievable breakdown of marriage had always been the sole ground, which will be proven by establishing in England one of the 5 facts, in Malaysia currently one of 4 facts, right? It's very similar, all right? The previous law in England, basically it's either adultery, behavior, desertion, separation. In England, they had 2 years separation with consent and also 5 years separation. Okay? If, say, the parties don't consent. All right? So that was the case before. All right? Now they have abolished all of that. There's no fault at all. It's basically you have to be married at least for a year. And if you could prove that, there's irretrievable breakdown of marriage, you're divorced. Okay? You can go through this process without a solicitor. All right? You pay 600 over pounds and the divorce happens at the court. Okay? So it's as simple as that.
600 pounds. That's actually very
600
very
over pounds.
affordable compared to, I think, some of the Malaysian divorce.
You don't go through a solicitor, you see. But if you go through a solicitor, then it incurs more charges.
Of course.
Now, the move for them was not easy. There was a lot of challenges in passing this law, especially the concern of, are we making the divorce law any easier? Right? And then it goes back to the question of sanctity of marriage, the societal stability and whatnot. The move is in accordance to the societal needs in England. Right? Now, their focus is more on the ancillary matters. How do you manage your life after the divorce? People don't come to divorce at the very first argument. It happens over time. If you recall all the dramas that we spoke about in class, yes, right? People don't come to that breaking point so easily. But then again, I need to qualify. Different generations, different approach to life.
Maybe.
Okay? Now, usually people don't come to a point of divorce that quickly.
Let's hope not.
Yes. So, see, it all depends on how society evolves. Okay? From living in a community, now individualism has become a way of life. People think about themselves. Am I happy? Am I happy in this marriage? If I'm not happy, then why do I need to invest this much of energy in it? Yeah. I can have the option of moving out from this marriage, stepping out from this marriage. So, and marriage has become very accessible. Right? So, divorce rates go up.
Yep.
Okay? So, bearing all these in mind, and after so much of research, so in England, they found that rather than focusing on saving marriages, the focus should be supporting families who are separating to settle down well, in terms of how the children are going to be managed. Okay, maintenance for the ex-spouse, how properties are divided, the division of property. So the ancillary matters will actually help them to settle down in life. So that's how it has shifted. But whether Malaysia is ready for it, well, let's just analyze the law itself.
Sure.
Okay. See, we have got 3 grounds.
Yep.
Yes. One is conversion to Islam that we discussed.
Yep.
Okay. So that's very peculiar, right?
Yep.
Okay. That's one. Which, of course, you can ask for ancillary reliefs and all based on that ground. Now, the second one is mutual consent.
Yep.
Okay. So in that, usually parties agree on how they want to divide their properties and child custody matters and all that. Okay. The third ground is where the fault-based facts are there. All right? You prove the irretrievable breakdown of marriage by showing that the other party has committed adultery, or there is a behavior that is, unreasonable for us to expect the petitioner to live with the spouse, desertion by the other party, right? Or 2 years separation. Okay? So these are the so-called, the first 3 are called the fault base. Okay, now, if we want to remove it, there must be a reason for it. What do you think is our reason?
I think there are a lot of people who would suggest that grounds to, especially fault-based marriage, fault-based divorce, lies in the fact that, you need to find a particular egregious wrongdoing by the other party, and some of the marriage that go into divorce does not actually end up in that point, but there might be a reluctance of one spouse to divorce, and so a particular spouse might find it very difficult to file for a unilateral divorce, and so would ask for some of a relief from the court. It's not impossible. It's just that it's quite rather difficult if the other spouse is very much reluctant or indeed resistant towards a unilateral filing of divorce. So I think a lot of people would say that in Malaysia in particular, that incurring not only is incurring the expense of divorce very, very high, now that you have introduced a barrier where if, let's say, one spouse find it very difficult to file a divorce with another partner who is reluctant or resistant in the breakup or the divorce procedure, this is a very, very high cost because they need solicitors to do the business for them to, file certain matters, write letters, and this is also a very much longer time. And you add in children, other matters, division of property, and it gets very heated very, very quickly. And once you're there, some parties find that it is, in certain stages of their life, they could find it almost impossible to file for divorce. And I think as society progresses, I think while we do want to encourage definitely the sanctity of marriage, not letting people get into marriages just because they're hot-headed in the moment, but I think there is also a reason. There's also reasonable ground to be had that where a marriage has irretrievably broken down, not due to a very egregious, let's say, behavior, desertion, or adultery, that there should still be a way out for some parties who find it no longer feasible to stay in a marriage. But, there are a lot of more conservative voices in Malaysia that says by doing this and that you might be making divorce rates go up. And a lot of people would say that look at South Korea, look at America, look at any other country which are advanced and have a well-developed divorce law, and they would say that they're not even having enough children to go above the replacement rate. And you definitely, in Malaysia at least, I think the social stigma around children outside of wedlock is definitely a faux pas that most people would not go through, and so would definitely marry in the cases of a unwanted pregnancy. And with relation to that, I think it is much rather difficult for some people to find themselves divorcing a person when, let's say, in Malaysia, I think you can get married as a female at the age of 16 with the consent of the chief minister. How do you back out of that, I think, is one of the questions. Do you think Malaysia is ready for that change?
Cultural sensitivity is very different. Okay? Now, if a party wants to step out from marriage without raising any of the fault-based grounds, okay? One of the facts that they can prove is 2 years of separation, but that requires 2 years of withdrawal from marriage life, okay? And 2 years can be difficult for some people, okay? Though the law doesn't specifically require for living under two separate households, but living under the same roof and having to prove that there's total withdrawal of family life, it can be challenging if the other party asserts that, no, we have been living together, we have been sharing life. So that makes it difficult for that party to go through divorce, which is a true concern, I must say. All right? So are we mature enough for this change? In my opinion, I think if the society is acceptable towards, okay, it is a process, things happen, they have divorced, fine, or they are going through divorce. People can go for mutual divorce. But the actual issue here is one party not wanting to let go, and the other party desperately wants to step out from marriage. All right? So that is what we are looking at. Hence, I would always hold this opinion that family law is not something, or divorce per se, cannot be handled like any other case. Okay? If a client comes to you, okay, say you are a family lawyer, a client comes to you, they may not come with a business tone and say that, oh, I've got a contract here. Can you please, these are the terms that, I would want to see in that contract. They don't come with that. They come with a lot of emotions. So family lawyers need to be equipped with different kind of skills. Yes, right? Being empathetic of the situation, but at the same time knowing what's best for your client. That's important. In the muddle of everything that's happening, the couple or the party that comes to you may not know what they want. So sometimes you have to be the adult there and the person who actually guide them as to what's best.
I think you raised a very interesting point, which is that in a divorce, it often gets messy and it gets real messy very, very, very fast. One of the matters that infuriates one party or the other or both parties is the ancillary matters. Who gets what? Which children goes to whom? How many hours do I get to see my child if the other party gets custody? Matters like this really, sets off a bundle of fire to an already desperately messy situation. How do you view ancillary matters, like the law on ancillary matters here in Malaysia? Because throughout my very brief internship, I would say, I've seen that there are people who have found it very difficult to understand the law on ancillary matters here in Malaysia. And not just here, I think it's also quite difficult for some people to understand why certain results could render from a dissolution of marriage, from the division of property to how much maintenance payments must be paid out over time, to even, so it's not only just your current property, but also your future assets as a whole. How do you view that in the context of Malaysia? Because that is a very, very, I would say, contentious point and topic here in Malaysia for a lot of people who have went through divorce. The matter could not necessarily is not necessarily about the divorce itself. It's about the ancillary matters, and they still hold on to grudges for years and years to come.
Yes, trust me, you are right. Now, it's interesting. Yeah. First of all, if people can mutually agree, there's no issues, right? Everyone's happy, right? Most often than not, that's not the case, yeah? Right. See, when your mind is not at peace, okay? When you have this feeling wanting to revenge the other person, you are so unhappy, you are having this fighting spirit, you're not going to settle. You're just going to aggravate matters. Yes, you're just going to say no to everything that is being proposed. That's usually the case. But then again, the role of the lawyer there is so important. Okay, so managing client and allowing them to come to consensus is important. But when consensus cannot be arrived at, okay, that's when the courts step in. Now, why the ambiguity is because it's the discretion of the court. Again, when we aim for certainty in law, flexibility becomes questionable, yes? Predictability is good, yes, but every case is different. Every situation is different. For example, what this spouse went through in marriage can be very different from another marriage, another spouse, right? And the needs of the children can be very different. Okay? So every case has to be dealt based on its particular circumstances, the facts. Hence, the unpredictability here. Whether it is good, I would say it's necessary.
Okay.
Good or bad is a different question.
Fair
but
enough.
It's necessary because fairness matters. Because here, when the parents cannot decide on the child's well-being, someone has to decide what's best for the child.
Definitely.
Hence, the court actually has got a very important role here because it's making a decision which is going to shape the child's life. Right? That's one. And when ancillary matters are being decided, especially division of property, for example, or money, maintenance, and all this, that is going to decide how that person is going to live his or her life. It has got an impact. So the role of the courts here, the judge here, is very big because that is going to have a big consequence on that person's life. So to me, flexibility, which comes from the discretion of court, is very important. And of course, the consequence is unpredictability, which is necessary in this area of law. That's my take.
Well, that's a very interesting take. I think, I would agree that it is definitely necessary. But as always, I think people under divorce will have very different takes than us lawyers who are looking at
or
this.
You may not have that right mind to take a position.
Definitely. But now moving into a more relevant topic to you as a lecturer, how do you find actually your classes in handling family law and because family law is a particular discipline of law that's not very much cut and dry like every other law, for example, like the like contract law, which you have taught me, which is very much more cut and dry. Here's the law, here's how it works. In family law, you learn through all the facts. You go through understanding how the law shapes, how the law is being shaped by the different facts that judges have to deal with, and how the legislature comes about with reactions sometimes to certain factual circumstances or certain hardships faced by people going through a divorce or other family matters under under a regime of law. Do you find it difficult as a lecturer to teach this very much more personal yet important subject of law?
I don't find it difficult. In fact, I enjoy teaching family law compared to any other area of law. I enjoy teaching family law because of the nature of it. It involves people, how people live lives, and when there's a problem, how do we get to help them resolve the problem? And it's very touching because I've got my students who are in practice and who are chambering, who have done marshalling with judges, who have interned, handling family cases, and they come back and they tell me, Miss, now I understand what you were saying. See, I always tell my students, when it comes to family law, it's not just about knowing the law. In Malaysia, for example, you have the legislations and you know how cases were decided. You'll be able to manage it. But the difficulty is not in knowing the law. It's managing people and genuinely wanting to help people from the misery that they're going through. It takes heart. It takes a person with real feelings to do that. And it's not easy. Why I say it's not easy is because family lawyers are in a position where they have to be empathetic towards their client, understanding of them. At the same time, you have to have the logic mind, the clarity as to this is what the law is, this is what's required, this is what I need to do this. And you need to have very good boundary as well with your client, because trust me when I say this, it can consume you.
Definitely.
I've had friends in practice who don't do family matters, or they choose not to do children-related matters because it's just too difficult for them emotionally. As someone who have studied counseling, who have done counseling, with some knowledge on psychology, I can say that it's very important for students, future family law practitioners, current family lawyers, to understand their role in the client's life. I'm not saying the client's case, I'm saying the client's life. Because if you look at it as a case, then it's just a case. You're of course, you cannot get personal over that matter, but you can make a difference. You can help the client to feel a little better. Your role there is to help them to solve this family problem. That's your role.
That's a very interesting take on the role of a
Yes.
solicitor in a family law
Yes.
matter. I think it's very interesting. So how do you suppose that, for example, your role as an academician here in family law to assist, for example, in the progress of family law? Because as you said, I think compared to every other discipline, I think it's very much more personal. It's about the client, and you have to manage client expectation, have to help with their life as a whole, because this, with relation to, for example, divorce and their ancillary matters therein, you are dealing with basically the trajectory of their future and also their current emotional state.
Yeah.
How do you suppose, as an academic, you can help with this progress of family law?
I think my role, now it comes to my
Yeah.
role, isn't
Yeah.
it? Okay. My role is in shaping my students' minds, making them understand that it's not just about earning money, because divorce has become easy money case, you
Well.
know? But anyway, so it's not just about money, or it's not just about, I'm a lawyer, I just got to do it, so I'm doing it. No. It's about shaping my students to understand what people go through. And if there's one issue here, there are so many different dimensions to it. And how perception of one party can be very different to another party's perception. That's one thing. Secondly, the development of law in making students understand how policies are made and why the policy is as such. All right? Sometimes the society is changing, but the law is too slow in bringing change. But why is that the case? Because there could be so many other issues that tie that down. Yes? So making them understand this, I think, is important. At the same time, if there's an opportunity for me to contribute to the development of family law in Malaysia, more than happy to contribute my expertise and ideas, right? But more than all that, I don't know who my student will become in the future. My student can become a politician, can be a parliamentarian one day. And if they could have this understanding of how society evolved and why it's important to cater to that, then I think I succeed in my life. I've imparted this knowledge and skill in my student. And if I get one student who's a policymaker or even a good family lawyer, I think I've done my part, and I think I can sleep happily at night and wake up happy and to meet my next batch of students. So yes.
Yeah, well, that's a wonderful take on your role as an academic and lecturer here. I think you've done definitely an impressive job teaching me, especially in not just family law, but also other laws such as trust law. That was one hell of a ride.
Excuse me.
I'd like to thank you for always being so lucid and definitely being so clear in your understanding of law. And in relation to that, the difficulties that come with especially practicing family law, the difficulties in relating not just the law to the case facts itself, but also how behind every case there is always a person struggling, sometimes to get out of a marriage, sometimes with the marriage itself. it is very heartening to know that, there are a lot of people and there are a lot of progress being done in Malaysia, while sometimes slower than we would like it to be. But also, I think we've touched on the necessary reforms that have been done. I think there are still a number of reforms that could still be done, but as the law stands, I think you're quite satisfied with it and optimistic about how the law family law especially, is being applied here in
It's
Malaysia.
developing.
It is developing. I think, as always,
Yes.
every area of law is developing, but also in Malaysia, I think family law stands at a crossroad that is very much more interesting than some other jurisdiction, because we have this intersecting public-private that's usually divided, but now colliding with each other in terms of jurisdiction, in terms of reading the constitutional aspect of family law into it. Do you have any other words you would like to share with us before we end this podcast?
First of all, I'm glad that you enjoyed my classes. And it's not easy to, it's rare to hear students say that, oh, I managed my equity and trust class. Thank you so much for that. I enjoyed the class. Okay, that's rare. Okay, so yeah. Well, I think I've said everything. And I always find happiness in seeing my students succeed, and I want to wish you all the best.
Thank you.
And congratulations.
Thank you very much
for graduating.
Yeah.
Right. You have been a very good student.
Thank you.
The class is never boring with you, okay? And always open for new ideas and always open up discussions. And I think you have got a way of thinking, which is interesting. You bring different perspectives. And I think I enjoyed that. And the class have also benefited from all those discussions that we had. Yeah?
Yeah, I hope so. Thank you very much for saying that you enjoy me as a student.
It's true.
It is.
It's true.
It is an honor, and also always, I thank you for being my lecturer, and also thank you for being on this podcast. It has been an honor to have this conversation with you. I'm sure our audience would have loved every part of that conversation, and I hope that you find it fruitful in all your future endeavors, especially with your new module,
Children, families, and the state.
Children's family and the state, which we covered today.
Yes.
Thank you.
It's my pleasure. Thank you very much, Benjamin.
All right.